Okay, here we are, week 6. Time flies. I'm having a really good time teaching this course again, and I hope you're getting a lot out of it. In week 6 or module 6, we'll be looking at two aspects. One, it would be the monitoring of property and the use of property, and also the built environment. What we mean by that is how our communities are developed or built up, the structures themselves, the way towns and cities are arranged, and zoning powers of municipalities and the state, which regulate the way we use our property. And in the second half of the lecture, we'll address public health emergency response, which we've all had our fill of now that we're coming through the back end, hopefully, of our public health response to the COVID-19 pandemic. But we've had plenty of examples in our lives which have touched our lives and impacted the way we go about our business and our lives. So let's begin with the regulation of the use of property and the monitoring of property. And government addresses public health concerns in many ways. We've already studied some of them, like the vaccination issues, quarantine and social distancing, of course, education, the control of commercial speech and messaging. But now we're going to turn to the areas where government addresses public health concerns by regulating the use of property and what we call the built environment. They do this by conducting inspections and engaging in the oversight or supervision of the way property is used. They use their awesome power of search and seizure. This is a scary power for a government to have. It's the power that the police exercise when they search a property looking for illegal conduct or contraband. But in the public health context, what they're looking for are issues which impact public health. We'll talk about nuisance abatement. Nuisance is the use of a property, or in some cases, the abandonment of a property to the point where the property itself or the use of it becomes a public health problem. We'll talk about takings. Takings are again, a very considerable power of government where the government can exercise, under some circumstances, the right to actually take private property and, in most cases, pay compensation for it, but in other cases, not required to pay compensation. We'll talk about when those things will happen. And of course, as I mentioned before, we will talk about zoning. Zoning are the laws. We have them all in all of our towns, which dictate what we can build on our property, how high, how big, how much of the lot we can cover in the business district, what sorts of businesses can be built. And it's all about trying to promote public health and a lifestyle which is desirable or deemed desirable by the community. Inspections and oversight are done at the local level and the state level and the federal level. At the federal level, we talk about Food and Drug Administration and USDA. We talk about Department of Homeland Security. And each of those entities will exercise their right to inspect business facilities and make records to ensure food safety and things like that. State and local authorities will inspect buildings and private residences, daycare facilities, healthcare facilities. You've seen state officials in some of the places where you work, just trying to make sure that you're conducting the business or your employer is conducting business according to law and regulation. Some of the examples historically of inspection and oversight were the mosquito abatement policies enforcement procedures during the 2013 Zika outbreak. Restaurant inspections. I expect that restaurant inspections will continue as our restaurants begin to open, but capacity is limited. There will be some enforcement of that. There'll be spot inspections to make sure that people aren't filling their restaurants above permitted capacities, and that the personnel who are working in the restaurants are observing all the protocols related to masking and gloving and things of that nature, social distancing. A lot of times inspections occur without prior notice, and that's generally okay because if people are doing business in a way they should not, to give them notice doesn't serve any particular purpose. You want to sort of catch them red-handed. This is not deemed to be a violation of procedural due process, by the way. Inspection grades on a restaurant can be published. They can be made public so that the consuming public has access to them and may change the way they go about choosing restaurants depending on the grades that are published. So these things can be damaging to a business. There are some limitations on the time and the manner of the inspection. They can't be disruptive of the business to the point where they're actually shutting it down or chasing people out as they do the inspection. And these are things that are just reasonable. Let's talk about search and seizure. As you know from your Constitution, which I know you refer to on a daily basis, we have in our Bill of Rights a protection against unwarranted searches and seizures. We have the right to live in our homes and conduct our businesses without fear that the government would, without any particular reason, come barging in the door to invade our privacy. There are limitations to this, but this is one of the most important protections we have under the Bill of Rights. Prior to the late 1960s in the public health field, our courts were pretty lenient in terms of allowing searches and seizures by public health officials and even by police. The ability to raid a home without a warrant was pretty lenient at that point. As the case law developed in our United States Supreme Court, it tightened up a bit. And the two landmark cases in the public health field are Camara versus Municipal Court of the City of San Francisco, which is discussed in your text, and also C versus City of Seattle. Generally, as we consider these two landmark cases, we know now that the law is and the rules are that the Fourth Amendment requires advanced warrants for even administrative searches. So generally, if they're going to come in and search a business, that is, search it, not just come in and observe it casually, but to come in and search and start poking around and looking around in the kitchens and the drawers and the closets, then some kind of advanced warrant is generally required. The government interest doesn't automatically trump the Fourth Amendment protection of privacy concerns, although when the government applies for a search warrant, they will explain to the judge why they need it and that there is a public health concern or a criminal violation in progress, some reason why they need that particular warrant. When circumstances become so emergent, however, that there's no time to get a warrant, then we have what's called exigent circumstances, which is, think of it in terms of an emergency. If we don't get in here and search this thing now, something terrible is going to happen. So those are warrantless searches. They can be conducted legally under very narrow circumstances, and the circumstances which justify them are called exigent circumstances. Later, we'll discuss New York versus Berger, which was the involved the junkyard, and also Players versus City of New York regarding a smoking ban. In Berger and Players, the rule on warrantless searches in the public health field was refined a bit. Those decisions and the laws which follow them provide that warrantless searches are okay in closely regulated industries. That's a key. Now, these have to be industries which are already under the auspices of a government oversight, like FDA, for instance, or Homeland Security, perhaps, or anything like that. OSHA would be another good example. So laws that provide warrantless searches are okay in closely regulated industries if these three elements are met. The government interest is substantial, and it usually is. They can normally articulate a good, solid public health reason for the search. Number two, though, a warrantless inspection is necessary. This would be because they need to preserve the element of surprise, because maybe this actor or this business is pretty good at covering up. Give them 3 or 4 hours notice, and they'll make everything look hunky-dory, whereas a warrantless search would come without notice, and you might catch them red-handed. And also, the government would have to prove that an adequate substitute for a warrant is present. In other words, in a closely regulated industry, that industry would have lower expectations of privacy than perhaps you would in your own private home. So someone who in a meat processing plant, which is used to random inspections, would have a lower expectation of privacy. That would weigh fairly heavily with anyone who's considering whether or not a warrantless search was conducted properly. Generally, the courts show leniency toward warrantless searches of residences and purposes and businesses when there is a solid public health purpose. Restaurants, we've mentioned before. Pawn shops. Sometimes pawn shops, not so much for public health reasons, but pawn shops because criminals, thieves, will tend to fence their goods, the stuff they pick up illegally. They will try to sell off through pawn shops. Animal and daycare, of course, and animal shelters and dealers are under scrutiny too. Obviously, the welfare of children in a daycare situation has to be paramount. So I think the court would show great leniency there if the government wanted to pop in without notice at a daycare facility. Adult stores, because of the issue of pornography, although the definition of pornography has drifted over time, there still is a line beyond which the material is strictly illegal. And nursing homes, the treatment of our elderly in nursing homes is also a big issue. And they would have a lesser expectation of privacy and could be subject to warrantless searches in the interest of protecting the health, safety, and welfare of the elderly who are the residents in the place. But even here, these rights are not unlimited. Next up, we have the concept of nuisances. Nuisance, we might say, if we have a young brother or sister, Mom, make him stop, he's a nuisance. But nuisance has a real definition in the law and in the public health field as well. And I like definitions because then I know that we all are thinking of the concept in the same way. So the definition of a nuisance is a condition, act, or failure to act which unreasonably interferes with health or safety of a community. There are two kinds of nuisances. There are public nuisances and there are private nuisances. A public nuisance is an unreasonable interference with a right which is common to the general public. When someone uses a property in such a way that it bothers everyone, interferes with their lifestyle or the enjoyment of their own property, then this is a public health risk and it is a public nuisance. Someone who's using their property in such a way that it is extremely noisy at all hours of the day and night would be committing a public nuisance. Someone who uses a business property in such a way that the property emits foul odors, which really make living near it or doing business near it unpleasant or untenable, would be committing a public health nuisance. A couple of examples in your text. Arizona had a law which was designed to abate conditions which lead to the breeding of flies, insects, and mosquitoes. During the Zika outbreak in 2013, knowing that Zika was carried by mosquitoes, there were laws and regulations enacted on the abatement of mosquitoes. New York has for some time been at war with rats. Mayor de Blasio's rat war is what they call it. But essentially, these are lifestyle laws which also promote public health. Nuisance abatement can come in many forms. In some cases, it could be an order by a local or state authority to clean up a property. If the property owner declines to take the measures which the government is asking them to take, then the government, the state or local, the town, whoever it is, might have the right to come in and clean it up at the owner's expense and present a bill and some fines. These fines can become judgments in court and they can become liens on the property, to the point where if the property owner then went to sell his property before he took the first nickel from the sale, he would have to pay off these fines. So this is pretty powerful. In the residential context, sometimes there'll be a vacant lot in the middle of a residential neighborhood and it's owned privately, but the owner doesn't care and allows people to throw garbage on it and allows the grass and vegetation to grow wild, which leads to the breeding of mice, rats, insects, and a town will often come by and require that they clean up that lot and keep the grass cut. Non-traditional uses of this power come in some forms which are described in your textbook. But you look at page 334. I hope it's the same page in the ebook, by the way. But in New York City, the city sued a tobacco wholesaler for selling untaxed products to the tribal reservations. In Chicago, they sued the Beretta gun manufacturer on a public nuisance theory, but they were not successful. That's the Second Amendment again. This is, this is the right to bear arms and the corresponding right to manufacture and sell arms coming into conflict with the city's initiative to try to get guns off the street. There are a few other examples on page 334. A private nuisance, on the other hand, is when a private party brings a suit or goes to court to stop an activity undertaken by another property owner. Let's suppose you live near a gun range, for instance, and the constant pop of the ammunition was bugging you, but it wasn't. But the owner of the gun range was perfectly within his rights to operate the range. You might go to court and try to get a judge to declare it a private nuisance and ask him to impose some restrictions on the operation of the gun range. Dairy farms can be stinky, emitting odors. So I'm not sure what you could do about that. Obviously, farming is a favored and quite legal operation in most communities, which are rural. So also, this comes up in the case of the First Amendment, uh, reproduction rights and abortion clinics. There are people who might sue an abortion clinic uh, to get them out for a couple of reasons. They might object to what's going on at the clinic, but also because there is an abortion clinic, there's also usually a good crowd of protesters who picket the abortion clinic. Having the protesting in your neighborhood all the time can be regarded perhaps as a private nuisance, but it's complicated because of the right of the clinic to conduct its business under the First Amendment and the right of the protesters to express themselves outside that clinic in a peaceful manner. Now we come to a big one. This is the section on the ability of the government to take private property for public purposes or to abate public health nuisances or conditions, which is more specific to what we're doing in this class. In this country, we take great pride in our right to own property and use it within limits as we wish to enjoy it, as we would say in the law. But the government also has the power to take private property under some circumstances, and in most cases they have to pay for it. In other cases, they do not. So, when the abatement of a public nuisance results in an interference in the use and enjoyment of private property, this could result in a taking. When the government physically occupies premises to the exclusion of the owner, or when the government permanently deprives the owner of the economic value of the property through regulations or other interventions, we then say that the government has taken the property. And the constitutional provisions which are relevant here are the Fifth Amendment, which says that the government shall not take property without just compensation, and the 14th Amendment, which applies that Fifth Amendment to state action. Remember, the original Bill of Rights, it was thought only guarded against federal government actions. And the 14th Amendment was enacted for the purpose of making sure that all of those protections also guard against our individual states infringing on our rights guaranteed by the Bill of Rights of the Constitution. So sometimes the government will actually come and buy the property from an owner, take it away. That's a physical taking. Usually it's for a public purpose. If a town or a state thought that a community needed a medical center because there were no close hospitals, there would be a valid public health purpose in perhaps condemning a piece of privately owned property which is not being put to good use for the purpose of building the hospital. The government takes property all the time for the purpose of building schools, parks, highways, and redevelopment. There's a famous case out of the U.S. Supreme Court called Kelo, which says that redevelopment, the town looking at a particular property and finding that it's underutilized and can be put to a better use, a more productive use for the benefit of the community, might use its redevelopment powers to condemn or take that property and pay the owner just compensation. Just compensation is whatever the property is worth at the time the government takes it. But sometimes the taking of property is not as direct as the physical taking of property for a public purpose. Rather, it comes about because the regulations which the government enacts have such a profound impact on the use and enjoyment of the property that the property uses all of its utility and value. We say that all of its economic value has been taken or diminished through this regulatory taking. Sometimes in the law, we call this inverse condemnation. There's usually a little bit of value remaining, but it's so small that for all practical purposes, it's as if the government had taken the property. So to decide whether a regulation has resulted in a taking, there is a test. 3 parts. The court will look at how severe is the economic impact of these regulations. Number 2, do the regulations directly advance a substantial government interest? In the case of public health, it would be, do they advance a valid public health purpose? And number 3, does the regulation interfere with the investment-backed expectations for the property? So if someone had a piece of property and they were putting it to some use and it had, perhaps it could have been developed for the construction of new apartments or single-family homes, then the regulation could, in some cases, impair the ability of the investor to execute his original redevelopment plan. This deprives the economic value and could result in a regulatory taking. Compensation is most of the time required of the government when they take private property. The Fifth Amendment requires it, but there are exceptions. So when the government is using the taking power to abate a nuisance, compensation is often not required. If you're doing something on your property like burning garbage in the middle of the yard, or using an abandoned house around the corner from where you live for some illegal purpose, and that purpose is a public nuisance, then the government could presumably come in, take your property, maybe demolish your abandoned building and abate the nuisance, and at the same time maybe not have to pay you for it. Instead, they might hand you a bill for demolishing the building and abating the nuisance. In connection with my comments on takings, I posted a very good article there. I want you to read the section in the text on takings. However, I also want you to read the article, and the article is entitled Public Health and the Taking of Private Property. Very good. I think it's a good summary of the government's powers in this regard. Next, let's turn to zoning in the built environment. Zoning is one of the most powerful tools that governments have. And typically, the zoning power is wielded by local government, your towns and your cities where you live. These are the laws which dictate how you can develop a piece of property. Every town has different zones. There are residential zones. There are multifamily residential zones where you could build apartment buildings. There are recreation zones where you can't build anything but a park or recreation facility. And there are commercial and industrial zones, which are sort of self-explanatory. The town uses these zoning laws, if they're using them correctly, to ensure that the development of the community is done in an orderly way for the benefit of the common good. The built environment is that part of the community which is the improvements that we make on land when we have it. The houses that are built on the various lots in town are the built environment. The stores downtown are the built environment. the roads and highways, the parks, the churches are all part of the built environment. The things that go from the ground up is the best way to think about that. Neighborhood planning, engineering, architecture are all fields of endeavor that contribute heavily to the built environment and inform the government when they enact zoning laws. When someone wants to develop a property in a way which is not consistent with zoning, they will be either prohibited from doing that, or they will have the right to apply for what we call a variance. They would go to the town and say, here's what I want to build. Yes, I know that the zoning will not allow me to build it as I envision it, but these are the reasons why I think you ought to let me do it. And sometimes variances are granted, and a lot of times they are not. The other tool that's used in the zoning field are redevelopment plans. This is where the government says that, listen, we have a large section of town. No one has built anything here in a long time. Perhaps it had been at one time in the past improved with factories run by industries which either no longer exist or which have moved out of the country. And we'd like to see something else built there, perhaps houses, perhaps parks. The town then will adopt a redevelopment plan after doing a big study, and basically the redevelopment plan expresses the town's vision for how that area should be developed. And this is a major tool in the zoning field. Also, I should say that when there are redevelopment plans in place, very often they give the government the power to take private property to see the redevelopment plan through. These would be physical takings, and they would require just compensation. So the source of zoning power is really state police powers. And back in 1926, in Euclid versus Ambler Realty, discussed in your text, the right of the state to exercise zoning powers was confirmed. There is a public health basis under the state police powers umbrella for exercising zoning powers too. Sometimes zoning is all about aesthetics. What do things look like? How do they work? But in other cases, zoning laws can be designed in such a way as to effect a public health purpose. For instance, the separation of industrial uses from residential uses might be a good public health measure. Perhaps industries are noisy, perhaps they're putting fumes or vapors or odors into the air, which would make a proximate residential neighborhood unpleasant, maybe even unhealthy. So separating the industries from the residentials would be a quite obvious one. Also promoting the distance between structures, or how many structures can be built on a given size building lot, is a public health measure, because we all understand that when we build a house, we like air and light. We want the sun to shine in our windows. We want to have a nice breeze through the windows on a hot night. And so light and air are important considerations, and I would say they're public health considerations as well. Ingress and egress. How do you get into a property or a neighborhood, and how do you get back out again? Can you do it without creating a traffic hazard? Traffic hazards and traffic laws can be seen as public health laws, in the sense that automobile accidents are those preventable injuries we talked about a few weeks back, and they are definitely on the public health hit list. And of course, providing parks and recreation and plenty of green space is always important. It has always been said that parks are the lungs of a city. We know that trees um, absorb carbon dioxide and give us back oxygen. So the lung analogy is a good one. But overall, any good, well-planned community will have plenty of green space and parks and opportunity for recreation. Recreation, of course, ties back into the issue of childhood obesity and actually adult obesity and chronic health conditions. If we can get people walking, running, playing tennis, perhaps we take some steps toward ameliorating chronic health conditions. And this would be done through the zoning power. Now, zoning doesn't always go unchallenged because zoning affects the way people want to use their property, and people generally hold to the principle that they should be allowed to do what they want to do with their own property. After all, they paid for it. But zoning can affect value. In some cases, zoning increases the value of property, but in other cases, it might diminish it, not to the point where it would then be a regulatory taking, but to the point where what the property owner thought he had is no longer that because of a zoning law. If someone bought a piece of property and thought they could build 50 single-family homes on it, and then a zoning law were passed which said that no, we're going to now create more light and space and green space in between, and now you can only build 25. Obviously, the property's worth less because you're only allowed to build and sell 25 houses instead of 50. These things are okay when zoning laws do them, as long as they're reasonable and they're related to the impacts that a project will have on a community. 50 houses in a given community in a relatively small space could have an impact on traffic, but it most likely would have an impact on schools as well. So these are valid local zoning concerns. Sometimes zoning is used to restrict fast food, trans fat content, sugary drinks, with the object in mind of addressing childhood obesity, diabetes, hypertension, things like this. The public health exercise of zoning powers has been upheld as long as there's a rational basis and uh, and it doesn't result in a almost complete deprivation of the value of a property. Just one more note there on the public health emergencies. I'm sorry, on the zoning in the public health field. You see a note at the bottom of the slide, homework, answer question 3. And here I intended to give you a little tip. The question goes to when in the public health field must the government compensate when they take property, and when are the circumstances when they do not have to compensate? And the focus there should be the idea of nuisance, because when the government takes property to abate a nuisance, very often they will not have to compensate and may even be able to render a bill for the services rendered in the abatement of the nuisance. Okay, let's move on now to public health emergencies and the response to same. Public health emergencies are the occurrence of or imminent threat of illness or death by conditions caused by bioterrorism or novel or reemergent infectious agents. That would be COVID-19. This is a novel coronavirus, but it is in some ways like ones that we've dealt with before. Biotoxins and things of that nature come under this heading. And a condition which poses a high probability of a large number of deaths or serious and long-term disabilities or widespread exposure, a significant risk of substantial harm to large numbers of people in a community. So that's the definition of a public health emergency. We've been in a public health emergency since early March. We probably should have been in one. It should have been declared a month or two earlier, but perhaps we missed the boat on that. The definition is a bit narrow because public health declarations have been issued for things like public water contamination. Here, I want you to consider the case of Flint, Michigan, and the contaminated water supply when the city decided to shift the source of the public water from the lake to the Flint River, which was a notoriously filthy and toxic waterway. As you know, it had devastating impacts in that community. Measles outbreaks come under this heading too. Shortages of medical marijuana. I would add to the shortages of PPE and COVID were a hot issue beginning in March and February when it was realized that we were going to have a big impact here in the United States, but didn't have the PPE to equip our healthcare providers or our citizens. So shortages of medical supplies come under this heading. Storms and tornadoes result in public health emergencies. Katrina is a good example there. Hurricane Sandy with big impacts in this particular geographical area. Lead in the drinking water, lead paint in old buildings and apartments, and of course opioid-related morbidity. These all come under the heading and can be the reason for a declaration of public health emergency. Why are these emergencies declared? Well, they're declared because once declared, they trigger a whole arsenal of state and local public health powers, which in the absence of the declaration would not be available. Different states have different laws as it relates to public health, but as in other fields, the public health legal community has thought that when we get to things like COVID-19, where it's impacting many states or all states to one degree or another, it would make sense to have a little bit of uniformity as we move from state to state. For that reason, they've designed something called the Model State Emergency Health Powers Act, and not every state, I believe, has adopted it, but many have. And structurally, what it does is it sets up the planning, reporting, and the declaration of public health emergencies. It sets up rules for property management, including the destruction of property which should be removed in order to advance the public health initiative and to protect people through examination, treatment, tracing, vaccination, isolation, and social distancing. The dissemination of information, education is also part of that. That's a voluntary public health power. Public health emergency declarations trigger not only optional, often unavailable public health powers, but they expedite the use of those powers. They cut through the red tape, so to speak. For public health authorities, they're allowed then to respond together, police, fire, public health officials, all coordinating their efforts. Some optional powers involve the closing of roads, the declaring of curfews, the evacuation of areas, testing, screening, and vaccination, and taking of property, etc., etc. Governors acting with public health emergency declarations can suspend laws which already exist in order to address the public health emergency. There's an example in your book of current Vice President Mike Pence, when he was governor of Indiana, suspending Indiana's law which prohibited needle exchanges because there was an HIV/AIDS outbreak in 2015. So they thought it best to prohibit. So they suspended the criminal law which prohibited needle exchange programs for the suspension of the public health emergency. In the case of COVID-19, on a more lighthearted note, alcoholic beverage control (ABC) laws generally prohibit bars and restaurants from selling alcoholic beverages on a takeout basis. However, these laws were suspended during our current COVID-19 public health emergency, and because these businesses were in trouble and basically closed, they were allowed, of course, to produce food for takeout, but they were also allowed to sell beer, wine, and cocktails on a takeout basis. Of course, public health emergencies open up the coffers, the treasury, for the expenditure of tax dollars to address the public health concerns and to reallocate our resources in such a way that we can address the emergency in an effective way. We've said throughout that most of the public health power that we've seen exercised in this crisis and in past crises is exercised at the state and local level. This is where the government is closest to the people and has the biggest impact, right at the community level. However, the federal government also has public health emergency powers. There are certain laws on the books which can be triggered in a public health emergency. A couple of them are mentioned in your text: the Stafford Disaster Relief and Emergency Assistance Act, the Public Health Services Act, the National Emergencies Act, which was used after 9/11 and extended continually over the next 16 years, and the Pandemic and All Hazards Preparedness Act. The one which has been used most recently is the Defense Production Act of 1950, which was used by President Trump, specifically with the 3M company in mind, and the purpose was to kind of kick them in the butt and get them shifting maybe more of their production to the manufacture of N95 masks. There was a time when these masks were in great shortage. We had states like New York purchasing equipment, ventilators, masks from places like China and Korea, which is probably a source of some embarrassment to the federal public health officials, who were probably caught unprepared, fair to say, by the COVID-19 pandemic. These laws, again, are awesome. The Defense Production Act would really allow the president to, while not actually take over a company, to step up to that company and tell them, I know you make, automobile tires, but for the next 90 days, you're going to make as many masks or whatever the piece of equipment is as we need until further notice. That's what you're going to do in your factories. Okay, so this does interfere with the business of these enterprises, but in some emergencies, it's just necessary for the federal government to step in to direct the efforts of private industry, and that's what this is. So, as always, we have the public health powers, but then we have the legal and practical challenges of exercising these powers. It's the point, again, at which the rights of individuals and businesses come into conflict with the efforts of public health officials. One of the biggest practical challenges in the public health emergency context is coordinating the efforts of the federal, state, and local governments. You could see in the COVID 19 example that there was quite a bit of state and federal governments stepping on one another's toes. I think the states, the ones which handled it most effectively, New York, New Jersey, um, were very aggressive, seeing a little bit of inaction and indecisiveness at the federal level. They took the bull by the horns and addressed their state's concerns. In the case of New York and New Jersey, you saw the close cooperation of Governors Cuomo and Murphy, understanding that while they are two separate states, the tri state area is really a region, and doing one effort in one part of the region and a completely different in another doesn't make a lot of sense. So sometimes, without proper coordination and communication, the efforts undertaken by these three levels of government can be redundant, in conflict, inefficient, and the state may not feel bound to follow federal protocols, or the federal government doesn't even impose protocols, and the state feels like they have to be more aggressive in restricting the activities of their citizens. This absolutely happened with COVID 19. There was a time during the daily press conferences given by the president where the president claimed the right to open up and shut down state businesses within individual states, but that power does not exist as a matter of law, and that's plainly within the police powers reserved to the states under the 10th Amendment. So, in real time, when a public health emergency is upon us, there's a certain triage which takes place, which involves eliminating confusion as to the various emergency laws and communicating clearly between the key actors who are addressing the problem. The other thing that has to happen here is we have healthcare practitioners who are really working under emergency, almost battlefield conditions. And in order to encourage them to continue to work and to put themselves into harm's way, we have to protect them. So, protecting our practitioners and entities from liability in a public health emergency is an important concern. Governmental agencies are, for the most part, immune from liability for acts or failures in a public health emergency, and private public health practitioners and healthcare practitioners are a little bit uncertain about that. Will they be held liable for acts of negligence in performing services in a public health emergency? If there's some uncertainty about this, this might diminish participation when it's needed the most. And of course, sometimes a public health emergency requires that medicine be practiced decisively and even aggressively. And uncertainty about whether or not there will be professional liability could result in the practice of defensive medicine, which may not be in the best interest of the public health initiative. So, some things to bear in mind. During Hurricane Katrina, Dr. Anna Pu from Memorial Medical Center faced criminal charges um, stemming from 4 cases. It was argued that that she had participated, maybe in a passive way, in ending the lives of patients in this hospital. There was a civil suit which was settled, and the operator of the hospital also settled the cases for about 25 million. Um, but there, the hospital was accused of failing to adequately plan for this kind of an emergency. The PrEP Act provides some protection to manufacturers and pharmacy. And then across the country, various state laws provide some protections. But for on the federal level, we have the Good Samaritan Health Profession Act, which, as of the last writing, had not been enacted yet. It was still in bill form, and I think we should look into that. If anyone has a couple of minutes and wants to look into the Good Samaritan Health Profession Act of, well, it looks like 2017, but it might have been reintroduced in 18, 19, or 20. Let's find out what the status of that was, because I'm sure this is going to come up as we treated all these COVID patients under emergent circumstances. I want you to remember that here for Module 6 or Week 6, modal is supposed to be down until Monday. So over the weekend of I guess the 26th, 27th, 28th, Moodle will not be available to us. For that reason, any written assignments and, of course, your case study 1, will not be due Sunday night at 11:59, but instead, let's move that to Monday, June 29th at 11:59. Thanks. I'll see you next week.